Good morning, everybody. We are just waiting for a few more people to join, so we'll just give everyone a few more minutes, and then we will get this very exciting training going. Thank you. Okay. Welcome everyone. Hello. My name is Amanda Rinquist, and I'm from the Black Sash. I'm the National Education and Training Manager at the Black Sash. And I'm very excited for today. I think this is one of the most exciting projects that I've worked at while being at the Black Sash. And it's exciting because for two reasons. One is that the work of paralegals is essential to access to justice in South Africa and are the first frontline workers in ensuring that people's rights are upheld in South Africa. And so to be able to provide a legal resource or a resource to paralegals is something that the Black Sash deems exceptionally important and is part of our programmatic work. The second reason I'm excited for today is that the issue of debt, credit, and consumer rights are fundamental in South Africa, especially prior to the pandemic, but especially as people require more and more of a lifeline in the form of credit because of the financial situation that we find ourselves in South Africa and that individuals find themselves in. And so making sure that people are properly protected is something that we think is fundamental. And that is why we have this very, very exciting manual, which we will send you a copy of after this launch, so that you have the correct copy and you are free to distribute it amongst other paralegals. Print a copy for you. We're going to try to make as many hard copies available to reach for collection at our regional offices, or through different ways. We have printed quite a number of them. So we're going to try and make this as widely available as possible, but it is also available on our website. And so, yeah, and so we want to thank you for attending today, and thank you for attending this training that we think is going to be very important. We want to thank the London School of Economics and Political Science for funding this very, very important book. And we want to thank Stellenbosch University Law Clinic for helping draft this very important manual. I do not think that Deborah is here from the London School of Economics, who is going to share a few words, but if she joins later, then we'll definitely have her say something. But I'm going to give it over to my colleagues at Stellenbosch University Law Clinic to talk about why this work is important to them, what they've done in this field, and yeah, and then we can get going. So Josie and Odwa.
Thank you, Amanda. Just switching on our cameras. So I have with me, my name is Odwa, and I have with me Josie. So we're from the Stellenbosch University Law Clinic, and we're involved, as Amanda indicated, mostly on this project on the drafting of the manual. So we've been involved in this project since the beginning of the year. We've updated the manual for Black Sash and added a few chapters to it. So the manual basically is a manual pertaining to debt, credit, and consumer rights related matters. It deals with how, as a paralegal, you can deal with clients when they come to you with matters pertaining to all those three sections that I mentioned. So the manual deals with the National Credit Act. It deals with the CPA, which is the Consumer Protection Act. It also deals with acts that are related to debt and credit. So what we did in the manual, we tried to make everything simple for paralegals in order for them to be able to consult with the client but not only consult with the client, but advise the client as to what's the next step forward after you've consulted with that specific client. So the manual doesn't only give you information pertaining to those specific legislations and matters that are related to credit, debt, and consumer rights, but it takes you a bit further and it gives you the way forward as to how you will deal with the specific issue. So the manual is quite, it's a long manual. It's over 70 pages, but it's worthwhile reading. And on our advice and on Black Sash's advice, we advise that you read the manual in its entirety. So you don't just read the manual for that specific section that you want to relate to. So it's better if you read the entire manual so you can have a better understanding of how everything works. So basically on our side, I'll give a brief introduction of the work that we do. So as Amanda has indicated, we are the Stellenbosch University Law Clinic. So we are a law clinic that's a fully fledged attorney's office. We deliver legal services to the poor and the marginalized. At the same time, we also train final year students with practical legal training. So our clinic is situated in Stellenbosch, and we have satellite offices in Worcester and Ceres, which we visit once a month. And then we used to have another satellite office in Somerset West, but due to COVID, we had to close it now. So the clinic basically has, it's a small to medium firm. We have 4 candidate legal practitioners. We have 5 attorneys, and then we have our normal staff. So the core business of the clinic is to support communities that are within the Boland area. So the Boland area would be your Worcester, your Stellenbosch, your Paarl, your all those areas within that area. So the types of matters that we deal with, it's mostly related to eviction matters. So both PI and ESTA matter. ESTA matters. So ESTA matters is farm eviction. So the farm evictions, we're the only ones that oppose in the Boland area. We're the only law clinic that opposes farm eviction. So we're the only ones that oppose those applications. We also have a family law department. So our family law department deals with divorces. We deal with maintenance matters. We deal with domestic violence. We also do children's rights matters. And then we have our general civil department. So our general civil department deals with motor vehicle accidents, debt-related matters, so on and so forth. So as the clinic, I'll just tell you about our accomplishments. So during the past 4 years, the clinic has received the following awards. We've received the South African Social Justice Law Firm of the Year award from 2019 until 2021. We've also received at the South African Specialist Awards at the 10th Annual Global Law Experts Awards, we received South African Specialist Law Firm of the Year. We've also, at the same awards, received an award for the South African Niche Law Firm of the Year. We've also received 2 silver awards at the MACE Excellence Awards. We've also been shortlisted and we are finalists in the Gender Mainstream Awards in the category Empowerment of Women in the Community. We've also received an award for the first Institutional Media Excellence Awards in 2018 as a newsmaker. So how we got involved with Black Sash was through our impact matters. So Black Sash noted our impact matter in the Constitutional Court in 2016, which dealt with what we call emoluments attachment orders. We also have recently, we've had a certification of a class action, which was granted in the Western Cape High Court. But that matter is still on appeal, and we're waiting for the leave to appeal application was heard on the 22nd of October, and we're waiting judgment on that matter. We also had a victory in the Western Cape High Court in the past 2 years in what we call the Ndupla matter. And in that matter, it has also been appealed to the Supreme Court of Appeal, and we are waiting judgment in that matter as well. We were also involved in the Equality Court, where we assisted a Paralympic swimmer who was being discriminated against by a wine farm within the Boland area, who refused him entry because he had a guide dog. So we assisted him in that matter, and he actually got compensation for the amount of 50,000, and 50,000 was also donated to the Guide Dogs Association. So those are our impact matters, and that's the work that we do as the Law Clinic. So I think, Amanda, you can start with the first animation. Thank you very much.
Thank you. Give me 1 second. Ooh. 1 second. Sorry, I'm panicking now. I had this all figured out yesterday.
Amanda, can I play it for you this side?
Okay, thanks, Ernest. Sorry, I have it open here. I'm not sure what's happening.
Okay, which one is the first one, Amanda? Let's see.
Assisting clients.
Here we go. Wait, let me see. Assisting clients. Sorry guys, we'll get there now. Here we go, assisting clients, ne?
Assisting clients. Meet Tuli, a paralegal at Vuga Community Advice Office.
Her role, or rather the role of any paralegal, is to educate, assist, and advise consumers in matters such as debt and credit, consumer rights and responsibilities, credit bureau, and consequences of being over-indebted, to name a few. Please note, although Tuli can assist clients to budget and better manage their finances, she is not allowed to give financial advice. As a paralegal, this is how you should assist, advise, and educate your clients. Remember to always consult the Black Sash Debt, Credit and Consumer Rights Paralegal Manual to familiarize yourself with important issues. Before the meeting with your client, make a photocopy of the client record sheets as well as the information sheet. You will use this to note down any important information during the interview with your client. Upon your client's arrival, introduce yourself and your work and tell your client what you can and cannot do to help them. Ask the client to give you copies of any accounts or documents they may have brought with them. If they have received any documents but not brought them with them, ask them to bring them to the next meeting so you can be clear about the situation. If your client is having trouble paying back their debts, you will have to assist using the assessment in Chapter 2 of the Black Sash Paralegal Manual. Assess how serious their situation is, making sure that the client understands that the nature of the assessment is informal. This may include assessing the payments they are still making or should be making. If you think that they are over-indebted, you can. Number 1. Advise your client to speak to their creditors and arrange with them how they plan to pay off their debt. Number 2. Alternatively, you can advise them to apply directly to the magistrate's court to be declared over-indebted, and the court may rearrange their obligations. Number 3. As a last resort, if their problems are beyond their ability to negotiate, they can approach a registered debt counselor who will negotiate a repayment plan with the credit providers on their behalf. Advise your client to listen carefully to the information that the debt counselor provides them with. Ask questions and try to seek independent advice before signing the application form for debt review. If a credit provider has been reckless in granting your client credit, your client can apply to court or tribunal, as the case may be to have the credit agreement declared as reckless. If a court or tribunal declares that a credit agreement is reckless, the court may either set aside all or part of the consumer's obligations under that agreement or suspend the credit agreement until a date determined by the court. If your client has received a written notice, letter of demand from the credit provider, check if proper procedures have been followed. See Checklist 1 in the Black Sash Paralegal Manual on Debt, Credit and Consumer Rights on Written Notice. It is very important for your client to respond to a written notice. It is still not too late for them to negotiate with the credit provider or to see a debt counselor. If legal action has been taken against your client, consult Chapter 5 on legal proceedings on the Black Sash Paralegal Manual on Debt, Credit and Consumer Rights. Check if legal procedures have been properly followed and advise your client how to respond. This could include you helping the client to respond to the allegations. See Checklist 2, the consent to judgment and the summons, as well as Checklist 3, court orders in the Black Sash Paralegal Manual on Debt, Credit and Consumer Rights. If your client has been treated unfairly or unlawfully in any way, and they want you to act on their behalf, check that you have the client's permission in writing to pursue this with the suitable institutions. If there have been no faults in the process, start to work with the client on possible solutions to their situation. You need to find out what resources and ideas the client may have to solve the problem. Your advice will be important in helping them to exercise their rights and to think of constructive ways of finding solutions. For detailed information on how paralegals should assist clients, please refer to the Paralegal Manual, Assisting Clients section.
Thank you, Ernest. So there are 4 animations which we will be playing throughout today's training, and they are all available on the YouTube, on our YouTube page, which link I will post in the chat also. Back to you, Josie and Audra.
Thank you, Amanda. So we're gonna share our screen. We have put together a presentation. So basically, we've structured the presentation as follows. So for part 1 of the presentations, we will do chapters 1 to 3. And then for the second part, we'll do chapters 4 to 6. And then for the last part, we'll do chapters 7 to 8. So like we indicated at the start, this manual is basically a guide for paralegals. It doesn't give you all the information on debt, credit, and consumer rights matters. So it places a responsibility on you as a paralegal to go a step further and find the research on the specific issues. So what we recommend is that you'll see in this in the manual, once you receive it, that we refer to cases, but we provide a brief summary of all the cases and also the legislation that's included. We provide a brief summary. It's your responsibility then to go to those cases and read those cases and get a better understanding of those cases before you consult with your clients. So without further ado, I'll provide you the structure also as to how we'll deal with the training. So Josie and I will swap around with the chapters. I will deal with chapter 1 to 3. Josie will deal with chapter 4, 6, and 8, and all the other chapters I'll deal with. So don't be alarmed if you hear a lady's voice and you think you're listening to me. That will be Josie. So we'll start now with the manual itself. So the manual, like I indicated to you, it's a guide on debt and credit and consumer related matters. So the guide offers you the use of the NCA, which is the National Credit Act. It also gives you legislations that relate to credit, debt, and also consumer related matters. So what does that mean? So it means that when clients have gone to a credit provider to borrow money, then this is the perfect guide to advise those clients on the situation that they'll find themselves in, be it that they think that they were given high interest rates, given that they think that they were given credit that they couldn't afford, which is reckless lending, or they've taken up too many loans and they're not able now to pay all those loans, which is over-indebtedness. So what we advise you here is that look at the guide. We have checklists, we have assessments that explain to you how do you deal with those specific situations. So for example, if a client comes to you and they're over-indebted, how do you deal with that situation? So in this guide, we also give you a brief overview of the legal process that will follow. So for example, if your client went to a credit provider, which is like a FNB, to ask for a personal loan, and now they're unable to pay that loan, what will happen? Normally, they will get firstly a letter after 30 to 60 days from FNB saying, okay, your account is overdue and you're not paying account. So that's where then the legal process will only start once they get served with a letter of demand, which is a section 129 notice. So you'll see, we'll describe it as we go with the manual. So that explains to the client, okay, this is where you defaulted, this is how much you owe, and this is the period that we will give you in order to pay the sum. So this guide gives you advice as to how to deal with it. So what this guide doesn't offer, so this guide is not a financial advice manual. So you are not a financial advisor as a paralegal. So you mustn't give financial advice to a client because you're not registered as a financial advisor. It doesn't give training of a debt counselor because you're not a debt counselor either. So you mustn't, unless you are a debt counselor, then you can give advice on debt counseling, because I know some of you might be paralegals and debt counselors. So if you are those two, then you can obviously give advice on debt counseling. But if you're not, this guide is not a training of debt counseling, and it does not list doesn't provide a list of debt counselors and credit bureaus. So your role as paralegals is to basically educate, assist, advise, empower the clients that will come to you pertaining to matters that relate to what we mentioned. So you need to have the capabilities to assess, negotiate any of the credit agreements that the clients come to you, where you will then communicate with those credit providers that the clients went to. So again, when you are confronted by a client, there are certain steps that you need to take before a client comes to you. So those steps are, you need to prepare yourself before the client comes. So you need to place documents in front of you that will assist you when and before those clients come to you. So you will know the documents that you will need for that specific client. So if a client is coming to you and you know it's a matter that's relating to credit, for example, then you go on the manual, you take out, we've specifically made it possible that you can take out the checklist and the assessments out of the manual so that you can print them, and then you just go through them with the client for that specific matter. So it's important that you prepare yourself before you do the consultation. It's also important that you introduce yourself to the client and you introduce the work that you do. So you need to explain specifically to the client what you can and what you can't do, how you can assist the client and how you can't assist the client. So that will encompass the work that you do. So that's you explaining, okay, this is what I can do, this is what I can't do, this is what my work involves, okay? And then when you are in the consultation, it's very important that you get all the details of the client that you're consulting with. So these details will include obviously the FICA documents, which is the ID, any proof of registration, anything like that, to prove that the person that's in front of you is actually the person that they purport to be. So an ID will tell you, okay, if I say I'm Josie Parks and then I don't produce an ID that says I'm Josie Parks, obviously I'm not Josie Parks. So those are the things that you need to look out for. And then when you're consulting with the client, it's important that you keep a proper record of that client. So you can do follow-ups with the client, and then when you've concluded the case, you can tell the client. So how do you keep a record? You write down everything, all the client's information, their contact details, their address, so on and so forth, so that when you give them advice on what to do going forward, you can easily contact them after they've left your offices. So again, we emphasize that it's quite important that you do follow-ups after you've consulted with the client, so you can keep the client updated as to what's going on in the matter. And then after you've concluded the case, you contact the client again and you tell them, okay, this is what I've found, this is what you can do, and this is the way forward in your matter. So and then we deal with the National Credit Act, which I said we will say it's the NCA going forward. So the NCA was introduced in South Africa on the 1st of June, 2007. So basically it relates to all matters that relate to credit and debt. So all agreements that are post the date of 1 June 2007 must be subject to the NCA. And some that were entered into before this date, provided that they meet the conditions of Schedule 4 of the NCA, might also fall within the Act. But you must remember the key here is that they need to have those specific conditions that are set out in Schedule 4. So the NCA becomes a very important, so from 1st June 2007, the NCA became a very important legislation when it came to debt matters. So again here, we provide a summary of the most important sections within the NCA that we think that you should be aware of, but it's your prerogative that you go further and you read the NCA in its entirety so you can get a better understanding of what it says. So obviously, like I said, there are certain exceptions that apply to the general rule that it applies wholly to all credit agreements. So there are specific credit agreements that it doesn't apply to, and those are where an organ of state is involved or the state is involved. So the state being the government or any department within that space, or where a debtor, for example, is a juristic person, so a person with a legal personality, that would be, for example, a company. So not a real person, not a natural person. So the purpose of this act, as it was put in place, is that it wanted to promote a fair and non-discriminatory marketplace where everyone can have access to credit. And then it needed to provide a general regulation of credit and improved standards for consumer information. So we all live in South Africa. So our past is very dark. And because of our past, some groups have been closed off from acquiring credit. So what this does is that it protects consumers and it gives them the right to apply for credit. It protects them against discrimination, which is something that is very important in the context of South Africa specifically. And it also, because credit is something that is sensitive, people must know what they're entering into. So therefore, it also states that your clients, when they enter into a credit agreement, they need to have a copy of that agreement so that they know exactly what they entered into. So we will deal with the questions only after we've done the presentations. So you're more than welcome to note your questions in the comment section. Then we'll deal with them after we've concluded the presentations and the animations. So chapter 2 deals with owing money and being in debt. So this chapter basically deals with what do you do now when you are placed in a situation where a client is owing money and they are in debt. What do you do? So in this specific section, we provide specifically what do you do when your clients find themselves in a specific scenario. So what do the clients do? So we first explain why do clients get into debt. It's basically simple. Everyone gets into debt for the same reasons or similar reasons. So these reasons are you are unable to pay your monthly expenses. So your monthly expenses will be rent, transport, groceries, school fees, vehicle fees, so on and so forth. So things that are constant within a month that your salary is unable to cover, or your your social grants that you receive are unable to cover. So we also say that people also get into debt because of emergencies. For example, family death, sudden illness, hospitalization of a family member, so on and so forth, where you didn't plan for those things, and then suddenly you need instant money. So the only way you can get instant money is if you go and apply for a loan. We also include things like paying school fees, where suddenly you're unable to pay the school fees and you need some assistance there and there. We also say the luxuries include buying a car, buying furniture, and then starting a small business, and then other luxuries. So when people borrow money, it's where they can afford, and there's a problem that is present within that space. So this happens when people are tricked into buying things, accepting credit without knowing the extent of the interest, borrowing money to fix a debt, but using it for other things. So that's what we describe as you borrowing money for things that you don't specifically need. So where you say you're going to borrow money for one thing and then you use it for another thing. So we then say, okay, if your client has borrowed this money and they're owing this money, how do you assess that client? This is where we say you need to assess the client's financial position. So here it's where you go to what we call sheet 3 and sheet 4 and sheet 5 on the menu, where the client comes to you. You need to get a better understanding of their financial situation. So the only way you can get a better understanding of their financial situation is that the client discloses all the information that you will need in order to fulfill the obligations that you will have on the sheets that I alluded to. So what you will do is that a client may seek advice from you to help them understand their financial situation and how to manage the debt that they find themselves in. So what you need to do as a paralegal is that you need to find out your client's debt use. How do they use debt? So that's where you say you relate to sheet 3 on this manual, which deals with debt information. Right? So once you have all that information, then you do what we call a list of the income and expenses. So money coming in, money coming out. So this is where you start drawing up a budget for the client, where you say, okay, this is how much you earn and this is how much you spend. Is it sustainable? Is it not sustainable? How can you fix it? Okay. And then you use the client bracket. You will see where we relate to sheet 4, which is the budget. And then you go to sheet 5, which is the household expenses. This is where now you deal with, okay, this is how much I will spend based on what I need to buy for the household, or over and above that, if you have children outside of the household, what are the expenses? So basically it will be the expenses of the client. Okay. And then once you've done this exercise, you can then assess properly what the financial position of the client is. So once all this is done, then you'll be in a better position to advise the client what they need to do after you've obtained all this information. So some clients might find it difficult to pay their debts, okay? There are many reasons why people find it difficult to pay their debts, okay? Some fail to pay pertaining to the, if you fail to pay, obviously you're in breach of the terms and conditions of the agreement that you had with that specific provider. What that means is that now you are placed in a position where you are in default, which means that you have not maintained the terms and conditions of the agreement because you have failed to pay within the specific time which you were allowed to pay. Okay, so once you find yourself in this position, there are certain steps that will follow. So if one, there is no legal action that is taken against your client, they can approach the credit providers, so the person that gave them the money as a loan. So they can approach them and say, hey, man, I'm struggling, I'm unable to pay this 3,000 Rand anymore that I agreed on. What can we do? Can we minimize the monthly payment to a payment that is more affordable to me to pay? Obviously, what that means is that because you are paying less now, the debt that you have will be extended. If it was, for example, a debt for 5 years, where you were paying 3,000 every month, if you're going to pay 1,500, that will be extended now to a period more than the 5 years. For example, it might be extended to 7 years, where you will have to pay that 1,500. And obviously the interest will also be increased because the duration of the payment increases. So what we say here is that it's not only you that has the responsibility. So it's not only the clients that have a responsibility, but you also have a responsibility to approach the specific credit provider and say, okay, my client is struggling with making monthly payments. Can we enter into an agreement where I say they're going to pay this amount and this is the amount that they can afford? Okay, so you also are able to communicate with credit providers. But you need to bear in mind, some credit providers don't want to speak to paralegals, and they might prefer to deal directly with debt counselors. So also, then you need to advise your client that they need to approach a debt counselor so they can communicate with those credit providers. So if your client then is unable to make the payment arrangement, then it's advisable that you tell them that they need to consult a debt counselor. Okay, so what happens now when your client stops paying? And then the second scenario is where a legal process will then commence. So what will happen is that your client will be sent monthly statements by the credit provider saying, okay, this is how much you owe for this period. This is the amount that's overdue. This is the interest that will start to run from the date in which you became indebted or you defaulted on your payments. So your client will receive those monthly statements. If they fail to pay the amount that's outstanding or continue to make payments or make a payment arrangement, then what will follow is what I indicated is called a letter of demand, which is a notice that the client needs to pay this amount and that they're in default. Okay, they normally give the clients 10 to 14 days to rectify. If they fail to do so, then a legal process will ensue, which we will explain further in chapter 5. Okay, so what is this written notice, the letter of demand that we keep speaking about? So this is a letter that is governed by section 129 of the NCA. It basically, like I indicated, sets out that your client is in default. This is the amount that they're in default for. This is the amount that they need to pay in order to settle the default. This is when the interest on the default started to run, and they need to pay it within a specific time, or else they will start a legal process. So when your client receives this document, it's very important that they shouldn't ignore it. They should you should inform them that they either need to contact the credit provider to make arrangements. So arrangements will be, okay, I'm only able to pay this amount? Can you assist? Or is it possible if I defer the payments to another month where I'm able to rearrange my finances and pay that amount in its entirety? So you can also assist in this period by writing to the specific creditor and making those arrangements on behalf of your client. So you also need to advise your client to apply for debt review if they prefer to deal with debt counselors, or if you think the case is too complicated for you. So your client might be, remember at the start, we said we'll deal with over-indebted. Your client might be over-indebted. So if your client is over-indebted, it means that they're unable to pay the installments of all their debts when they become due without borrowing money from somewhere else. So here, the only institution that can set aside a client over-indebted, that can declare a client over-indebted, is a court. So the client will then need to approach a court to declare that client as being over-indebted. Once the client is declared as over-indebted, then only a court again can declare that status, that they're over-indebted, null and void. So only a court can set that aside, remove that status. So we also deal here with reckless lending. So reckless lending is basically where a client is given an amount where obviously they won't be able to pay it back. So these issues are mostly where a client who earns 3,000 Rand, for example, is given credit for an amount of 50,000. Obviously, they won't be able to pay those installments. And obviously, they won't be able to facilitate that credit. So that amounts to reckless lending. So the NCA places an obligation now on credit providers to do an affordability assessment, to do an assessment that will indicate whether the client can afford to enter into the agreement or not. So if your client, you think your client, the agreement that they entered into is reckless, then you need to approach the court, or you need to advise them to approach the National Consumer Tribunal. Okay, so now we deal with consumer rights. So this section deals specifically with matters that relate to the Consumer Protection Act. Okay, so the Consumer Protection Act again applies to most transactions, except transactions that relate to a state. So the state, again, like I explained, will be the government, and also a juristic person and bargaining agreements. So here we just tell you which sections that we think are important. I won't go through them in detail. You'll see them on the manual. We'll go through them in detail. So section 8 and 10 relate to the right to equality and of the consumer to and market protection. So this right basically relates to a free and unlimited access to goods and services. So it kind of explains itself. And then section 10 relates to the right to lodge a complaint. So where a client feels that they weren't treated well, then this specific right relates to them laying a complaint. Then sections 11 and 12 relate to the right to privacy, where the client can then say they don't want to receive certain direct marketing, where you receive SMSs on your phone, where letters are posted on your mail that you must buy these certain things, so on and so forth. And you would have seen now with OPI, creditors and service providers need your permission before they market to you directly. And then section 12 deals with the right to discontinue receipt of direct marketing. This is where you have a client has prescribed to a subscription that they need to receive a news ad from Edgar's or whatever every month, they can then say, I don't want this anymore. And then sections 13 to 17 and 20 to 21 deal with the client's right to choose. So they right to choose which suppliers they want to engage with. They right to choose whether they want to cancel or renew a fixed term contract. They right to request pre-authorization for repairs and maintenance. The right to cancel direct marketing agreements, the right to cancel advance reservations, bookings, and orders, and the right to return defective items. And then also the rights to disclosure of information are dealt with in sections 22 to 28. This is where your client then has a right to receive information in plain language and in a language that they can understand. And that, for example, that prices need to be displayed for those services in full view of the client so that they have an understanding. Okay, and then section 27 deals with agents and sales brokers, that they need to disclose to the clients who they affiliated with and who they represent. Okay, section 28 then deals with the right to information about identification of installers. So, for example, if someone comes to your house and then they want to install a geyser, they need to identify themselves. And then sections 29 to 39 deal with the right to fair and responsible marketing. So this basically relates to where you receive a coupon, an example for a spa treatment. And then when you get there, they say this is expired, so on and so forth, and there was no explanation to that. And then sections 40 to 47 deal with the right to fair and honest dealings. So this basically places a responsibility on service providers to act in a manner that's clear and not misleading. And then here we relate to our recent case, which you can read, which basically deals with this question in greater detail. Okay. And then we say the CPA then deals with consumers' right to be heard and obtain redress in sections 68 to 71. This is where a client is given the opportunity to enforce their rights that are given by this specific legislation, either through alternative dispute resolution, a complaint with the commission, or going to court, provincial structures, or the tribunal. So basically that encompasses how we envisage you will deal with those three chapters. So we'll stop sharing our screen now, and then Amanda will take over.
Thank you so much for that, Odwa. So I think we're just going to share, I don't know if Ernest is still around. I can share the consumer rights one, or are you going to? Oh, Ernest is still here. And so so Ernest is going to play the next animation, which takes a lot of what Odwa has just said and puts it into a nice 4-minute video on just some basic issues with consumer rights, or basic rights that consumers have. Thanks, Odwa.
When credit is granted recklessly. Under the National Credit Act, credit providers have a responsibility to make sure that a consumer can afford to pay back the new debt. Credit may be granted recklessly if: number 1, the credit provider did not do all of the following checks before offering credit: the consumer's personal income and expenses, the income of any financial partners within the family or household, the expected future income of their business, and whether they can make repayments on time according to their financial means, prospects, and obligations. Or number 2, the credit provider did the assessment but nonetheless granted credit even though the outcome of the assessment showed that the client could not afford to pay back the debt and would become over-indebted. Or number 3, it was clear that the consumer did not have a general understanding and appreciation of the rights, risks, and costs involved in the proposed credit agreement. Let's look at a quick case study that perfectly illustrates the offering of credit recklessly. Meet Miss Adams. She has just completed her studies to become a teacher. Miss Adams needs a job to pay off her student loan and microloans she took out for her textbooks and transport. Excited about entering the workforce, she decides to go clothing shopping in order to look good for her forthcoming job interviews. Miss Adams goes to a clothing store and asks if she can open a clothing account. She explains that she is a new graduate and that she is excited to start working as a teacher, but has no job yet. The salesperson informs her not to worry, as she will soon get a job. In the meantime, she can buy clothing on credit and pay her monthly installments to the shop once she gets a job. The store and Miss Adams reach an agreement to open a store card for clothing, and a small loan is granted to Miss Adams. She purchases clothing worth 1,000 Rand. After 3 months, Miss Adams still does not have a job. She now has her study loan, clothing account, and a microloan to pay. She is very worried. Luckily, she has heard about a local advice office, the Vuga Community Advice Office, and goes to seek advice from a paralegal. After hearing Miss Adams' story, the Vuga Advice Office paralegal, Tuli, thinks that Miss Adams was granted credit recklessly. Miss Adams had clearly explained to the store that she did not have a job. This means she had no income to pay back the credit. Tuli believes that if the credit provider did a proper assessment, the outcome of the assessment would show that Miss Adams could not afford to pay back the debt and would become over-indebted. Tuli uses the Black Sash Debt Credit and Consumer Paralegal Manual to explain what this means and gives Miss Adams the name of a reputable debt counselor. If Miss Adams has been recklessly granted credit, she can apply to court or tribunal to have the credit agreement declared as reckless. If a court or tribunal declares that a credit agreement is reckless, the court may either take away all or part of Miss Adams' obligations under that agreement or suspend the credit agreement until a date determined by the court. Check out the Black Sash Paralegal Manual on debt, credit, and consumer rights for information on what type of loans the National Credit Act doesn't deem as reckless credit. For detailed information on reckless credit, please refer to the Black Sash Paralegal Manual.
Thank you so much. We're going to play video training 3 also, not this one, Ernest, that's on the screen. But the assisting clients one. Sorry, that one Ernest, Odwa and Josie are going to go into also a bit more. But this is about so it's training video 2. Ernest, not this one.
Oh, what is the title, Amanda?
It is entitled Consumer.
Consumer, there we go.
Yes, that's one. Sorry. So yeah, these videos, like I said, they'll be made available to everyone, and we encourage you to share them with other paralegals so that the very important work of the manual is also very easily understandable. So this is the next one, which talks about consumer rights, which is what I just spoken about now.
The Consumer Protection Act, known as the CPA, sets out the minimum requirements that must be met by suppliers to ensure that consumers have their consumer protection. Some of these consumer rights are: 1. The right to equality in the consumer market and protection against discriminatory marketing practices. A supplier cannot treat a person differently because of their race, gender, sex, or similar grounds, nor should they charge consumers different prices for the same product. 2. The right to privacy. Consumers have a right to protection of their private information and should not receive unwanted letters, emails, SMSs, or phone calls because businesses have shared their personal information to marketers. 3. The right to choose. Consumers have a right to select their own suppliers, to cancel or renew fixed-term agreements, to request pre-authorization for repairs or maintenance services, to cancel reservations, bookings, or orders, and to choose or examine goods. 4. The right to disclosure of information. This means receiving information in plain and understandable language. 5. The right to fair and responsible marketing. Consumers are protected against fraudulent, false, misleading, and unlawful marketing. 6. The right to fair and honest dealing. Consumers have a right to protection against the following: false, misleading, or deceptive representations, fraudulent schemes and offers, pyramid schemes, and overselling and overbooking. 7. The right to fair, just, and reasonable terms and conditions. This means that contracts must not be one-sided in the supplier's favor and must not have false, misleading, and unclear terms. 8. The right to fair value, good quality, and safety. When consumers purchase an item from a supplier, it must work, be of standard quality, and safe use. 9. The right to accountability from suppliers. Consumers have a right to protection in lay-by agreements and in respect of prepaid certificates, credits, and vouchers, and to access prepaid services and service facilities. 10. The right to be heard and obtain redress. Consumers have a right to enforce their rights, to resolve any dispute through alternative dispute resolutions. Consumers can lodge a complaint through the Commission, the Tribunal, provincial structures, or a court. Let's look at a case study on consumer rights. Meet Nozibele. Nozibele bought her children Christmas clothes on lay-by at Easywear. Nozibele cannot have the clothes until she has finished paying for them. No interest was charged, and so the total purchase price remained the same. Unfortunately, Nozibele has lost her job and can no longer continue making further payments. Nozibele wonders whether she is entitled to cancel the agreement. Nozibele visits the Vuga Community Advice Office to seek advice. Tuli, the Vuga Community Paralegal, consults Chapter 3 of the Black Sash Debt, Credit and Consumer Rights Paralegal Manual and informs Nozibele that the CPA regulates her lay-by process. Section 62 of CPA states that a lay-by agreement may be cancelled at any time. If she cancels the agreement, Easywear may only charge her a maximum cancellation fee of 1% of the total purchase price. Any money that she paid to date must be refunded in full, minus the 1% cancellation fee. Easywear cannot offer Nozibele a credit note as an alternative to a cash reimbursement. If this is done, she can report the shop to the Consumer Goods and Services Ombudsman. For detailed information on how paralegals should assist clients, please refer to the Paralegal Manual Consumer Rights section.
Thank you very much, Ernest, for showing for that. Hope you guys are liking well, you guys have a copy of the manual, and I hope you're liking the animations. As you can see, there's a lot in there, and so I'm just gonna I'm just gonna give it back to Odwa and Josie to carry on with the training so that we can know exactly how to use this manual to help our clients. Odwa? And then also I'll just give everyone a warning just before we go on the break later on. After this next session, we want to take a group photo. If you would put your cameras on later on, just like to give people fair warning. Odwa, are you there? You are muted. Oh wait, let me unmute you. There we go.
So Josie is going to now take over this section. So again, we're going to share a screen. So this section is basically chapters 4 to 6. Josie will do the bulk of the chapters, and then I'll only do chapter 5 in this specific section.
Good morning, everyone. As previously introduced by my colleague, I'm Ms. Parks. I'm the family law attorney here at the Stellenbosch University Law Clinic. And I assisted Mr. Nweba and our other colleagues with the finalization of the manual. So today, chapter 4 is about debt relief mechanisms. Now, essentially, as Odwa alluded to earlier, if your client has already tried negotiating directly with the credit provider, or you have done it on their behalf to arrange a payment plan and it hasn't been successful, and legal proceedings have not been instituted, and your client seeks advice on how to deal with all of the debt that they have. So we are therefore going to be looking at some debt relief mechanisms. So the 3 remedies we're going to be looking at is voluntary sequestration, administration orders, and being declared over indebted. So the first is voluntary sequestration, which is essentially an application that your client makes at the High Court based on all of the money that they owe to their creditors, and because they cannot pay back their outstanding debts. The effect of this is quite severe because your client will no longer have control over their estate, which essentially constitutes all of their assets and liabilities. So how does it work practically? The court, through the master of the High Court, will appoint a third party to take over and manage your client's estate. The consequences, as I've said, is quite severe, and we have a few examples. It's a very expensive process. The client will be blacklisted for 10 years or until they are released of the legal implications of being bankrupt or the sequestration. They will not be able to apply for more credit, and it might take them a very long time before they are able to apply for credit, even if they are no longer under sequestration. So even if the 10 years have lapsed, it might still be difficult for your client to obtain credit thereafter. Their assets will be liquidated. So this basically means that all of your client's assets will be sold to help pay back their creditors. And this is where sequestration differs quite a bit from the other mechanisms, is that the client's assets have to be sold in order to assist with the payments. Their status will also be affected in that they cannot have certain professions once they've been declared or have undergone sequestration. The second example is an administration order. And here an application is made to the court. So this is in terms of section 74 of the Magistrates Courts Act. And here the court itself will determine which amount the debtor has to pay back towards their creditors. Here an administrator is also appointed to collect the debtor's money each month and pay up all the debts as they are listed in the court order. So practically, usually the administrator can be an attorney, and in these cases, your client will pay a portion of their salary to that administrator each month. And then perhaps after 3 months, the administrator will divide those payments into portions for each creditor, but the amount is usually very small that the creditor then receives. The requirements are that the debtor has to have only a few assets, low income, and has financial problems, and they have to owe less than 50,000. So this differs substantially from sequestration in the sense that only if you have debt less than 50,000, you can apply for an administration order. Whereas if you have more debt, then sequestration would be an option. The third is debt counseling. And what does this entail? So the NCA, as Odwa has mentioned earlier, which is the National Credit Act, governs this remedy, and it helps consumers who have too much debt and are also struggling to make their monthly payments. It basically affords the client a second chance to pay off their debt, and they are assisted by a debt counselor. So the purpose of debt counseling is to basically assist the consumer to negotiate with the creditors on the amounts that needs to be paid back. And it also helps consumers if they have been granted credit recklessly. Odwa has explained what reckless credit is earlier. So just in general, if your client wants to approach a debt counselor to undergo debt counseling and you refer them to someone, or if you are someone who is a registered debt counselor yourself. Oops, sorry, I just went to the wrong slide. Okay, thank you. So a debt counselor has to be registered with the National Credit Regulator, and they have to display the certificate where it is clearly visible in their office or in a window or on their wall. Only natural persons can qualify for debt counseling, and the application for debt counseling can only be made if a creditor has not yet approached the court to initiate proceedings. So as Odwa has explained earlier, sometimes when your client is in debt, the credit provider will send them a letter of demand. And if they don't respond or they don't effect payment, legal proceedings will be initiated by way of a summons, which we will also get to at a later stage. But if your client wants to undergo debt counseling, that can only be done if the legal process has not yet started. So the process of debt counseling, there are essentially 5 steps, which we will look at briefly. The first step is the application process. So here, the debtor has to complete an application form 16, which is submitted together with their ID, a list of their expenses, proof of income, and residence. Then there's an assessment process, which is conducted within 30 days of receiving the application. And the purpose is basically to assess why the client needs to undergo debt counseling. The outcome will then be communicated to the client, the credit provider, and the credit bureau. Then we have the negotiation process. So here the debt counselor will send a proposal for reduced payments to each of the credit providers. In most cases, the credit providers will also appoint attorneys, and that negotiation is then done with their respective attorney or with the credit provider itself. And it's basically to determine if alternative payment plan can be made. Then we have the restructuring process, whereby credit providers rearrange the credit agreements to be in line with the proposal or court order. So the proposal, after negotiation, if it is accepted, then obviously it will be made an order of court. Then the last stage is the clearance certificate, and this is where the client is no longer under debt counseling if they have paid all of their debts as arranged in full. So now the question is, who can be a debt counselor? Just briefly, this is a knowledgeable and independent natural person over the age of 18, someone who has the correct mental capacity, who has not been removed from a position that required them to be trustworthy, and they must have received the necessary training. The duty of the debt counselor towards your client and with regards to the process of debt counseling is to keep your client's information private, to give them access to monthly statements should they request to see them, to act professionally and reasonably when performing their services at all times, and to explain the entire process to your client and the costs involved before they sign the application form. And you'll remember that the application form is the first step in the process. So they need to make sure that your client has all of the information before the process is initiated. Okay, so debt review is when a consumer is unable to pay their debts and they are placed under debt counseling. We can then say that they are under debt review until they have paid all of their debts. So the two can be seen as synonymous. It's debt counseling, debt review. You can see them as the same process. Then we just have some advantages and disadvantages of debt counseling. So the advantages is that your client is afforded a second chance to pay off their debts, and it places a barrier between the debtor and the creditor. As we mentioned earlier, in order for your client to undergo debt counseling, the legal proceedings should have not yet been initiated. But once they start the process of debt counseling, then their creditors are also prevented from instituting legal action. So it creates a barrier between the debtor and the creditor. And a good debt counselor will have the necessary knowledge, experience, and influence to negotiate with the creditors for some good or better payment terms for the client. The disadvantages, on the other hand, is that it will bar your client from accessing more credit, therefore no credit card, garage card, store cards, or withdrawals on overdrafts. This is similar to sequestration in that they cannot access any more credit as long as the process is underway. They will be listed with the credit bureaus and all of their creditors will be informed. It does not afford your client a payment holiday. They will still be making payments while the process is underway. It can also be costly as they will be paying the debt counselor and the payment distribution agency that usually collects and distributes the payments. They also lose some autonomy with regards to their finances. If the debtor is enlisted as incompetent or an dishonest debt counselor, it can cause the debtor significant financial damage. And that is why it is important that the debtor or your client checks that the debt counselor is registered and that they have the proper training. And of course, your client will lose the asset that led them to become over indebted in the first place. So those are the three debt relief mechanisms. I will now hand over to Udwa to go through chapter 5.
Thank you, Josie. So this specific session deals with what we touched on in chapters 1 to 3, which is the legal proceedings. So firstly, here, we explain to you what the legal proceedings are. So basically, the legal proceedings in this matter is where your client is in default, and then the credit provider then takes action against them through, firstly, a letter of demand, and then summonses thereafter indicating that they need to appear in court. So you would see, and specifically in South Africa, these legal proceedings proceed in what we call the civil way of things. So in some countries, debt-related matters are dealt with in criminal court. So where if you don't pay a certain amount, you can be sent to jail. In South Africa, however, it's dealt with in the civil sphere. And then there are no aspects of your client going to jail for not paying a debt. Okay, so in our manual, we say for you as a paralegal, there are certain things that you need to look out for. Yes, we know that you are not attorneys, but there's certain things that you can advise your clients on before they approach attorneys once they have received these papers. So once your client has received the summonses or a letter of demand, these are the specific things that you need to look out for. The first one is what we call prescription. So prescription specifically deals with where, for example, a client entered into an agreement with the credit provider, and then as per the Prescription Act, they can no longer approach the court in order to claim that specific amount because a certain period of time has lapsed since your client was in default and no action has been taken by that specific credit provider. So the general rule is that it's 3 years. So if your client, for example, defaulted on the 31st of, or the 30th of September, 2017, and then no action was taken by that specific credit provider, and then suddenly on the today, the 27th of October, they decide to send your client a letter of demand, and then thereafter they institute an action in civil by way of summonses. Then obviously that specific matter has prescribed because it's over the 3 years. Okay, so prescription is one, and then the second one is jurisdiction. So jurisdiction is basically, it relates to where a client entered into an agreement, and then that agreement was concluded in a specific place. The institution of an action, the credit provider approaching a court must be either in the court where the consumer resides or where your client resides, or he works, or where this specific agreement was entered into. So like we said, the proceedings are started with the Section 130 notice, where the client is notified that they're in default, okay? And then thereafter, you need to prepare your clients for going to court. So you need to advise your clients whether they entered into this agreement or they agree with the claim. If they agree, obviously you tell them, okay, then you need to do this and that so that you don't go to court. If they disagree, then you go back to those issues, whether there's prescription, lack of jurisdiction, and then you also deal with the merits. You see if the client was over indebted, it amounts to reckless lending, there was an overpayment on the client's part, or the amount claimed has been paid already. Okay, and then when your client decides that they agree with everything and they have no issues with it, then you do what we call a consent to judgment. So this basically says the client agrees that they owe this amount and they're willing to pay a certain amount towards that, the claim that is being claimed by the credit provider. Okay, so summonses is basically the document that summons, that tells your client you need to appear in court because you have failed to pay this amount. So it's very important, like we indicated, that your client doesn't ignore these documents, and failure to respond to them sufficiently with what we call a notice of intention to defend might result in what we call a default judgment being granted against your client, which means then they basically will have to pay the amount unless there are certain reasons why they will say they haven't received the summonses, which we'll deal with later. So a default judgment is a court order that basically says the consumer owes this amount of money and then they need to pay for it. And then this specific process where they need to pay can be done in one of three ways. It's either the credit provider will then repossess by taking the goods of your client, which will be furniture, any money that they have in their accounts, so on and so forth, or an emoluments attachment order or a garnishee order, which we'll explain later. Again, an EAO, we explained to you in the case that we've indicated here, which was a constitutional rights case. So you need to read that case in order to get a better understanding of what EAOs are. Although, again, I said to you that once they get a court order and it is legally binding, it can be removed, but what we call a rescission application. But obviously a rescission application, you need to meet certain requirements before you apply for it. For example, those are if the order was granted in absence of your client and your client did not know that this judgment will be obtained, whether there's an error in the judgment or there's fraud or mistake by all parties, including the judge himself or herself, or the judgment is based on an error, okay? So this application must be brought before the court 20 days before after your client had knowledge of it, okay? Which will then remove the court order against your client. And then a warrant of execution is basically where the credit provider has obtained this court order, and then they have what they call a warrant of execution, which then allows the sheriff to come to your client's house, attach property that they can sell in order to pay the debt and the execution fees that the client is liable for. Okay, so here I will explain to you what it entails, what can be taken, what cannot be taken, what the processes are for the client in order for the client to abide by the order by the sheriff. Bearing in mind that the only person that can institute and only execute that execution warrant is only the sheriff. So it's very important that that person that comes to your client identifies themselves as the sheriff, or they identify themselves as a deputy sheriff. So that's very important before they take anything. Amanda, I see the time now is 10:35. We can continue with chapter 6 now, or we can roll it over after we have a comfort break. I'm not sure what your position on that is.
I think, I mean, we've done so well. I think we should give people a little bit of a 5-minute stretch, kettle, toilet, but we'll make it 5 minutes. I'll play one 5-minute song. And when the song is done, can we all be back, please? And then actually, but just before we go to the song, I am wondering if people can, I'm trying to find the one, if you can just stop sharing your screen for a second, Audra. If we can take it's so great to have, there's almost 70 paralegals in the room. I know some people are joining via the different like together, and I just think it's so amazing to have an online training of almost 70 paralegals. So if people can put their camera on for us to do a quick photo, it would be really great. But don't be shy. I see Angelina there, see Esley, I see Dina, I see Ishmael, I see Connie Smith, Tiso, hello Tiso, hey Manta.
So once everyone's on, let's take a picture of us as well.
Okay.
Yeah, so you on, can you put your camera's not on Odwa?
Okay, we're switching it on now.
Okay, we got Evida, not yet. Ooh, we've got Dudu, we've got Khatat. Hi, Khatat, so nice hat. I like it, I like it. Hi, Sharif. Hi, Andiswasam. Yanni Hendricks. Hi, Lerato. Nice to have you here, Lerato. Okay. Aisley, will you take you got to do it 2 screens, I think, because there are so many of us. So you have to take a photo of the first screen and then the second screen. You got it, Aisley? Aisley not responding.
Sorry, I'm just having a problem with my sound. I missed what you said. Can you repeat, Amanda?
Can you take a photo of the 2 screens, please? Can you take a screenshot?
Yes, I get it. I see it as 3. It's actually 3, even though I have in gallery, it's 3. So everyone just.
So let's hold we must hold our smile for at least 10 seconds while they move
yes.
to all the screens. Hi, Teresa. I see Teresa also.
Okay, so going for the first picture, smile. Sorry about that. If everyone can just ensure that they are on mute, please.
Yeah, let me mute. Oh, sorry. Oopsie, I muted you by mistake. Let's try to get gallery view again, because now I have one person's screen on.
Yes. Same with mine.
Okay, I can actually you can just move your thing to there we go.
There we go. There we go. Okay, so
smile. Hi, Bonnie.
Okay, so now that's the first one. I just have to save that.
You're a full room, Jabulani.
Okay, got that one.
And then there's a third one.
Right. Now, no, one more. So I'm moving to the second out of 3. So that's where I see. Yeah, okay. So, okay. And then we got that one.
Hi, Abigail. Nice glasses.
Okay, and now we're going for the final one. Okay, I don't see a lot of cameras on for the final one. If you can, this is the third gallery view window. If you can, if not, I do know some networks are destabilized given load shedding today. I see still some coming on, some cameras coming on. Thank you for those that could. Koliwe and Ivashni, I don't know if you can. It's not on my side.
Don't worry then.
Okay.
So
Great.
thank you.
I think
We're
we've
gonna,
got all that we can get. Thank you.
yeah, so we'll come back at 1:45. So everyone can just grab a 5-minute break and we'll come back at 1:45 for the next session. And the question, I've noted there's 6 questions, and we'll do that when you guys come back. See you now in 5 minutes.
Oh yeah, that was Weatherby. I'd like to let you know that this song is very soulful, written by Mr. Wilton Felder, and I want him to know that you still love him. Mr. Wilton Felder, do you love him? That's what I'm talking about. We want you to know this was written by Wilton Felder. It's very soulful. We call this Way Back Home, written by Mr. Felder. Not to the others.
Okay, I'm glad that Simon appreciated my jazz selection. Thank you. I see Colin Vix is also smiling. I hope that means you appreciated the jazz. Yes, I'm very glad. My father taught me well. I was forced to go to jazz fests ever since I was a child and had no choice. But yeah, thank you. I'm glad we're all back. I see everyone is back. So Josie and Odwa, I've got to unmute you. I don't know why that keeps happening. Let me unmute you. And then, let's go for the second half.
Thank you, Amanda. So in this specific section, we'll deal with chapters 6, 7, and 8. Josie will take you again through the bulk of it, which is chapters 6 and 8, and then I'll deal with chapters from chapter 7. Okay. Thank you.
Hello, everyone. Chapter 6 is about contracting with a credit provider. So this section will contain some useful tips you can give your client when they are entering into a credit agreement with a credit provider. Okay. Sorry, I skipped by accident. So as Odwa mentioned earlier, people borrow money for a variety of reasons. He has already given you some examples, but I will just go through them again. At times it's to pay for your regular monthly expenses like rent or groceries. People also borrow money for emergencies, for school or tuition fees, to buy a house, a car, to start a business, or to pay off other debt. And usually before entering into an agreement, the credit provider is obligated to provide the client with the following: a quotation that is binding for 5 days. They have to explain the credit agreement in a language that your client understands, and it also has to be explained in simple terms. So not a lot of legal lingo or words that the client is not familiar with. They have to make sure that your client fully understands the content of the agreement, the costs involved and the interest charged, and also display their registration certificate in a manner that is clearly visible and proves that they have been registered. They have to assess your client's financial situation to make sure that your client can actually afford to pay back the loan or to get the credit. And they have to give clear written reasons if the loan is not granted, the name and address of any credit bureaus which they have provided information with their client's credit record, and to inform your client before they send negative information to a credit bureau. The credit providers may not keep your client's bank cards or identity documents, although they may use this to confirm the client's identity, and they may make copies. They cannot ask for your client's bank PIN code or refuse to borrow your client money based on their age, sexual preference, religion, race, gender, or any other discriminatory factor. Credit providers are usually banks, micro lenders, and shops. They must be registered with the National Credit Regulator, and they have to advise your client to first inquire if the specific credit provider is registered before they enter into a credit agreement. Once again, it can have a lot of negative consequences for your client if they borrow credit from someone who is not registered, and therefore it is important to make sure before you enter into the agreement. For an agreement to be valid, it must comply with the following. As previously explained, the parties must understand the terms of the contract, and it is therefore crucial that your client understands the terms before they sign. They must willingly enter the contract. There should be no force or duress, so they should not feel as if someone has forced them or made them enter into an agreement to which they did not want to be a party to. Both parties must be the age of majority, which is 18, and have full mental capacity to contract. And the terms and duties of each party must be clearly explained. So both parties need to be sure what is expected of them. And in an agreement like this, it usually entails the obligations of your client. So what should they pay back? How are the installments going to look? By when is the payment going to be made? So those are important things to note. Then some helpful tips before signing an agreement. The first is to never sign a form with any blank spaces on it. And the reason for that is if there's a blank space on an agreement, even after it has been signed, someone can easily add information in that blank space. So an easy way to solve that is to just draw a line through the blank space, and that will ensure that no one can add any information after the agreement has already been signed. Make sure that the agreement does not include a consent to judgment. So as Orwa has explained earlier, with legal proceedings, usually the objective is to obtain judgment. And it's very easy for these types of contracts to include a consent to judgment, which basically means that your client is already agreeing in the contract that if they don't pay, or if they don't pay by a specific time or a specific amount, that judgment can be granted against them. So it's very important to make sure that this clause is not in the contract. They should take their time to read through the contract as thoroughly as possible. They can even take it home and read through it with a friend or family member or other advisor before signing it. And they are definitely entitled to a free copy of the document, which they should also be able to take home. And then your client should be able to request from the credit provider a statement of their account without being charged for it by the credit provider, the current balance of the account, any amounts credited or debited, and the amounts that still need to be paid and by when. So paying back the debt, it's very good to advise your clients that the first two payments that they make usually goes to administration fees and interest, and only after the first two payments will they actually be contributing towards the debt. So after the first two installments, the debt will only be becoming less. If your client borrows money, they should always bear in mind that there are costs involved, and they should assess how much they can afford to pay back. And that is why essentially the first two payments don't even go towards the debt. It goes towards those costs that have been incurred. And also advise your client on the interest, which is always added to loans. And this can only be charged on the amount that the client borrows from the credit provider. If a consumer pays off the debt in full, they cannot be charged any more interest, of course. Then if your client is refused credit, so if the credit provider says, no, unfortunately, we can't provide you with a loan, or we can't enter into an agreement with you, they have to provide the consumer reasons in writing. The following would constitute reasonable reasons. For example, if the loan would be reckless. Audra made an example earlier that if someone, for example, earns 3,000 Rand a month, but they want to loan 50,000 Rand, this would be a fair assessment that they could not pay back that loan, since it would be reckless. And based on that, as a fair assessment, the client would then be over indebted and they would be unable to pay back the loan. So that is sufficient reason to refuse them that loan. The second is when a credit provider is unable to check the consumer's credit record, and when the consumer is negatively listed and is prohibited from borrowing any more money. For example, someone that is currently under debt review or under sequestration. So those persons cannot obtain credit, as we alluded to earlier. Then if your client has not been provided with sufficient reason in writing, they can query that refusal. So if they believe that the reasons were not fair, they can query this with the credit provider. And examples of when the refusal can be queried is where it was based on discrimination in terms of race or gender. There was an incorrect assessment of the ability to repay the debt, or where they were refused credit because they have seen a debt counselor before. I will now hand over to Audwa for chapter 7.
Thank you, Josie. Before we start with chapters 7 and 8, there's a few animation videos that we would like to play for you. Thank you, Amanda.
Sorry, I'm here. I was just trying to figure this out. Okay, here we go. This is the final video.
How to help a client who has received a written notice. Checklist 1. Written notice. When a consumer defaults on their payments, one of the first things a credit provider may do is send a written notice, sometimes known as a letter of demand. Warn your client not to ignore the letter of demand. Advise your client to pay the amount owing if they can afford to. If they cannot pay, they should speak to the credit provider and arrange to pay the money in manageable installments. If they ignored a letter of demand, they are likely to receive a summons. If the client did receive a summons, check whether it's a correctly issued summons. A default judgment is only permissible if the summons was ignored. If they ignore a summons, a creditor can apply to the court for a default judgment to be given against your client. The creditor may not begin any legal proceedings until 10 working days have passed since delivery of the written notice, and your client has been in default for at least 20 working days. The creditor may also not begin any legal proceedings while your client is working with the debt counselor, consumer court, or an ombudsperson. If you believe your client should not have had a default judgment made against them, they should contact a lawyer. If your client cannot pay the debt following a default judgment, the court can issue a warrant of execution. This means some of your client's personal items of value can be attached by the sheriff of the court as a form of payment for the debt they owe. Inform your client of their rights and the correct procedures for this. A warrant for execution. The warrant can only be bought by the sheriff of the court. The sheriff can open any door on any premises, even if access is denied. When necessary, the sheriff may use force in order to fulfill his obligations. The first time they visit the client's home, the sheriff may only make a list of all the things your client owns. Your client must point out items that belong to someone else or are not fully paid for, as they are not allowed to take these away. The second time they visit the client's home, the sheriff can remove their possessions. They may not remove possessions belonging to anyone else or which are not fully paid for. They may not take items of a personal nature or that your client cannot live without, such as their food, bed, clothes. Let's look at a quick case study. Meet Mr. Mbuli. He bought a set of pots for 3,000 Rand from Kitchen Essentials. The agreement was that Mr. Mbuli would make monthly payments of 600 Rand, including 20% interest over 6 months. After 2 months of making the payments, Mr. Mbuli was retrenched as a security guard, where he had been working. Mr. Mbuli was now unable to make the monthly payments for the pots. Although he still owed 2,000 Rand, he did not report his retrenchment to Kitchen Essentials. After failing to make his payment, Mr. Mbuli received a letter of demand from Nkosi Debt Collectors and a letter of summons that he ignored. After 1 month, Nkosi Debt Collectors came to Mr. Mbuli's house with a summons and removed goods from his property. They also took goods belonging to Mr. Mbuli's tenant. Mr. Mbuli decided to visit the Vuga Community Advice Office for assistance. After hearing Mr. Mbuli's story, Thuli, the paralegal, worked through Checklist 1, Written Notice, and Checklist 3, Court Orders from the Black Sash Paralegal Manual with Mr. Mbuli. Thuli explained that because he ignored the letters and summons, the court could, after an application from Nkosi Debt Collectors, issue a default judgment. Thuli, however, explains that the procedures taken by Nkosi Debt Collectors are incorrect. The sheriff of the court and not the debt collectors are supposed to visit Mr. Mbuli's home and implement the warrant. Thuli advised Mr. Mbuli to consult a lawyer. For detailed information on the written notice, please refer to the Paralegal Manual, Written Notice section.
Thank you. like I said, all of these videos will be made available online, but I'll just give it back to Odwa and Josie to go through the last few chapters of the manual, and then we've got everyone's questions here ready to get through. Thanks, dear, Odwa.
Thank you, Amanda. So now we're heading to the final stretch of the presentation. So we will be dealing here with chapters 7 and 8. So chapter 7 relates to what we call the credit bureau or credit bureaus. So the credit bureau is what I would say is the custodian of all information that relates to a creditor's history of obtaining credit. So if you've never had credit before, or your client has never had credit before, the credit bureau won't have any information on you. But immediately when you start obtaining or get credit, then that information is loaded to the credit bureau. So now we need to explain, or you need to explain to the client, what is this credit bureau and what is the role of this credit bureau? So like I said, the credit bureau is an organization that keeps information. So they have information of the consumer's record. They will have the name, which is a personal information, name, surname, ID number. They will have all the debts that you've entered into, all those agreements that you've entered into. So they will list, okay, you have an account at Edgar's for this amount. This is how much you've paid of your debt. This is the monthly payments that you've made. This is how many payments that you've missed, so on and so forth. So they have your information that pertains to the debt that you have obtained. So this body, like all bodies that are involved in credit, are regulated by the NCA. So when a creditor wants to give a client credit, what they normally do is that they go to the information that is loaded on the credit bureau to see if that specific client is a good payer. So what does that mean? It means that what is the likelihood that the client that is trying to obtain credit will be able to pay that. So the role of the credit bureau is to prevent consumer over-indebtedness and reckless lending. Because they have all the information that's related to your client's debt related information, then they can assist these credit providers before they can actually lend you the money with credit assessments. So you'll see, well, yes, you'll see when you're entering into an agreement, they normally ask you for permission to contact the credit bureau in order to get this credit assessment so that they can be placed in a position where they know whether you are a good payer or not, in order for them to advance you that credit. Okay, so that's the role of the credit bureau, is to advise and to restore, to keep information pertaining to the consumer's debt history. Okay, so the credit bureaus will list all the things that you have done, or the consumer or your client has done incorrectly, where they've not paid anything, where they've missed payments for a certain period of time, or there's a default judgment against you. So when there is a default judgment against a client, that will also be indicated on the credit bureau's website. Okay. So the CPA in itself makes provisions that affords the consumers rights to be informed of if a credit provider is going to report a negative report on your credit assessment to the credit bureau. So this must be done within 20 days. Okay. And then you would see that there is being new legislation now that has been put in place, which is POPI, the Protection of Personal Information Act, which relates to the protection of information that is kept by others, and how it governs basically how that information should be kept, how long it should be kept, who should have access to it, what permissions do they need from you before they disclose that information to anyone else. So the most important thing that is also in our constitution and also the NCA is the right to privacy, which relates to the confidential treatment of the information that you have. So this right is imposed, and the duty is imposed on the credit providers to keep your information confidential unless that information is provided to the credit bureau. So the credit bureau has to have that information in order to put it in the system so that other credit providers, sorry, there's someone that needs to mute themselves. Thank you. So that the credit bureau will then have that information at their disposal so that they can assist when you are trying to obtain, or your clients are trying to obtain credit again. So there's also section 68, like I explained to you, of POPI, that also deals with this. There's also another legislation, which is the PIA legislation, to some degree, that also ensures that the credit records of debtors or consumers are kept sacred, and they are not shared in an unfair manner. Okay, so we have what we call a credit report. Okay, so you are entitled to get your clients and.
Sorry, Odwa. Mabel, I note your hand, and we will get to questions very soon. So I'm just asking you, for those, we will get to questions. Just don't unmute yourself just yet, please. Thank you.
Thank you, Amanda. So we now here deal with what a credit report is. So a credit report, you're entitled to get one free credit report every year from any credit bureau. So how you can do this, you can either go to a credit bureau's website and request that one free credit report, or you can go, I think PEP Stores still does it. They also are able to give you one free credit report. So the credit report basically is the information that is kept for your client or the consumer by the credit bureau. So it will have all the information that are indicated to you: the name, the personal information, the addresses, contact details, employment history, the accounts that they've obtained, how these accounts have been managed, inquiries that have been made by previous credit providers on your account, any judgments that would have been entered against you, default or not default, any EAOs that you have, so on and so forth. So this information is again kept by the credit bureaus, and this information can be obtained from the credit providers or credit applications or the courts. Obviously, it's difficult to obtain it from credit providers because they might charge you a fee, but the credit bureau allows you to get one free credit report every year. Okay, so here we deal with the length of time in which the credit bureau can keep a default or a negative listing on their on their records. So there's a certain period of time in which that information can be kept on your record. The maximum is 5 years for an administration, sequestration, or rehabilitation order. So they must be kept for 5 years unless you make an application or your clients make an application to rescind the court orders, or the rehabilitation order is granted in case of sequestration orders, okay? So this basically means that the listing that will be placed on your client's record, you must explain to them that it will be placed for 5 years, for a period of a maximum of 5 years, and then thereafter they can contact the credit bureau if it hasn't been removed, that please remove this because 5 years has lapsed now. And then administration orders may also be removed from a client's credit record. Ordinarily for these ones, it's the maximum is 10 years, and then it will be removed automatically. Obviously, if it's not removed automatically, then you need to approach the court and then provide evidence that you're in a better financial position and that can be removed. Okay, so again, here we deal with how a judgment can be removed from a credit report. Like we said, there is the automatic one that falls away after 5 years. There is the application that you make to court for rescission, which we explained. And then you need, after you've obtained all that information, and then it's still not removed, then you can contact the credit bureau, make the information available to them, which will be a court order for the rescission, and then they'll remove it automatically. And then I'll hand over to Josie, who will deal with managing money, and then thereafter we'll take your questions.
Thank you, Odwa. So now we will be looking at some helpful tips that you can give your client on managing their finances. So the role of you as a paralegal in your client's finances pertains a lot to helping them draw up a budget. So it basically helps you educate your client on how to deal with their finances. And remember that when you help your client draw up a budget, you have to take into account the income of the entire household. So your client, their spouse, and any other persons that might receive an income within that household. And a client may be in debt for a number of reasons, and that may be the reason that they can't manage their money, because at times people just don't have enough money to pay for all of their basic needs. The following are some helpful tips on how your client can manage their money. The first is a lay-by. So essentially a lay-by means that instead of purchasing something once off and paying for it, this happens especially with clothing, your client can pay off that clothing or for a few months, and they only receive the clothing after those few months. So it gives them the opportunity to pay for the item over an agreed period of time. And laybys can also be cancelled. So if your client changes their mind, they no longer want the item, they should be able to get their money back. And there is a cancellation fee, which is capped at 1% of the total price. So if your client bought something or they laybyed something for 100 Rand and they change their mind, they should get 99 Rand back, which is most of their money. And they have to get their money back in cash. They can't receive it in the form of credit, which obligates them to buy something else from the store. And if they don't comply with this, they can be reported. Then cash versus credit. So it was also advisable that your client pay for certain things in cash, especially items that are smaller and less expensive. And they should essentially buy the bigger, more expensive items on credit, but only if they have assessed that they can afford to pay back the monthly installments. And then entering into more than one loan agreement should be discouraged, particularly if it's to pay off another one. Only money that is needed should be borrowed, and never more than that, because chances are the excess money will be used for something that it was not intended for, which leads to more debt. And then monthly payments should be made on time to avoid having to pay more on the borrowed amount. Because usually if your client is supposed to pay by the first of the month and they don't pay on that day, interests are added, which means that they are paying back more at the end of the day. Credit cards. Advise your client not to get one unless it's absolutely necessary. They should be used wisely and only if your client can make the payments on time. Interest rates. Your client should always try to go with companies that offer lower interest rates and are suitable for the purpose which they are borrowing the money and what they can afford. So there are different companies and banks that offer different interest rates, and it's good to try and find out who has the lowest interest rate before borrowing the money. Then there are also social grants. Clients should always be encouraged to refrain from entering into credit agreements with the money they received from social grants. And the reason, therefore, is that this money is primarily given to afford qualifying persons a means to cater for their basic needs and should therefore not be used to enter into credit agreements. Anyone found guilty of transferring, ceding, pledging, encumbering, or disposing of their grant can end up losing it and also face consequences such as imprisonment or the payment of a fine. Then we look at subsidies and other free services. It is good to advise your clients to look for bursaries or scholarships instead of getting study loans, which they will end up paying back for the next maybe 10 to 20 years. First-time home buyers can also apply for a finance-linked subsidy program where a subsidy is paid into the buyer's bank account or the financial institution who they are making the payments to every month. It is important to note that only households with an income between 3,501 Rand to 22,000 Rand can apply for the subsidy. Then attractive offers. It is important to warn your clients that sometimes deals are too good to be true because there really is a catch. So an affordability check should always be done by the client, meaning can they really afford to pay back this loan, or can they really afford to make this purchase? And it is important that they know the full costs of any credit agreement, including the interest, the administration fees, and what they will be paying back as a whole after the payments have been made, taking into account the amount they borrowed, the interest, and the admin. And then also advise the clients to stay away from any fraudulent activity, in the sense that they should not pretend to be someone else and provide false information when they are applying for credit. Shopping wisely. It's good to advise your clients to compare prices and offers and always try and get the best price or deal or the lowest interest rate before they buy something or borrow more money. Buying one good quality product works out better than buying cheaper products, which you will have to consistently replace in the long run. Cheaper products will cost more because they need to be replaced. If your client doesn't need something for a short period, it's better to just lend it from someone. Certain items can be bought at the end of a season when they are on sale, and then you therefore pay less therefore. And then also buy in bulk if you can, to use at a later stage. For clients who need to commute to school or to work or to varsity, can join Lift Clubs to cut on transport costs. And then encourage your clients to make use of in-store reward systems, which can help them save and get better deals on certain items. Another good tip is to not waste. Clients should only spend money when it is absolutely necessary. They should only buy what they need for their households and not excess which can go off and be wasted. Before buying another product, they should first use what they currently have. Money problems. It's good to remind your clients that to avoid money problems will not make them go away. It will only make them get worse. As Odwa has explained earlier, if a client receives a letter of demand, ignoring that letter of demand will not make the matter go away. It will only lead to legal proceedings being instituted and therefore legal costs being incurred and the process going further and further before anything has been done. So if they cannot pay back the debt, the best thing that they can do is to first go into the creditor personally and try and arrange or negotiate an alternative payment plan. And that payment plan should be according to what they can afford each month, even if it takes off a bit longer to pay the debt. Then the importance of planning, as the saying goes, if you fail to plan, you plan to fail. And the same principle applies when you fail to plan for your expenses. Therefore, it's good to encourage your clients to have a plan in place for both their current and later expenses, such as emergencies, by drawing up a budget that will help them plan. So we have 5 steps that can help your client control their finances for the month. Firstly, they should set guidelines on how much money goes towards their different expenses. Add all of the income in the household. As I explained earlier, the client, the spouse, any other persons who are living in the house, the estimate expenses, then those expenses should be subtracted from the total income to see what is left. Track, trim, and target, which is to see what the actual income and expenses are after drawing up the budget. And that is the end of our presentation. Thank you very much.
Thank you. Thank you.
Thank you very much. Now we have quite a few questions, and I have sent the questions in the chat to Odwa. Do you want me to read them out, or will you read them out?
Okay, I'll read them out. It's fine, because we'll deal with them. So I think the first question is from Tandiwe, and then it relates to the right to privacy. So just bear in mind, Tandiwe, so the question is how to respond to a marketing caller making reference to the fact that they got your details from the National Consumer Database. So in this specific scenario, you can do one or two things. Because there's legislation now that governs the sharing of information, which is POPI, you can report them to POPI that they've obtained your information without your permission, firstly, and that the National Consumer Database has shared your information without your consent. Alternatively, you can also report the National Consumer to the Consumer Commission for sharing your information without your permission. So those are the things that you can do in this specific scenario. However, I don't think that is the case that the National Consumer will share your information with a marketing consultant or whoever. And then the second question is, what is the difference between debt administration and debt counseling? Josie indicated already that debt administration relates to, basically, we also have a table, sorry, on the manual where we compare the differences between the two. But in a nutshell, debt administration is limited and it's capped at 50,000. However, debt counseling has no cap. So debt administration is dealt with through what we call an emoluments attachment order, where your client will be placed under administration, either through an attorney that will then facilitate the payment of the amounts or that are outstanding with specific creditors. Now, debt counseling relates to a process where a debt counselor then consolidates all the debts that your client will have and then indicates, okay, this is how much we'll pay this credit provider, and then this is how much, obviously, the debt counselor will also pay themselves. So in a nutshell, that's the difference between the two. And then the next question is from Chira. So Chira wanted to know, how much authority does debt counselors have? Because more often banks in particular call and inform you that if you don't make a certain amount, they will take legal action while one is under debt counselor. Okay. Many clients are frustrated as banks have no regard for debt process. Okay, if I understand this question correctly, then where bank contacts a client and says, Otto, could you please unmute? Thank you. So where in this specific scenario, if I understand your question correctly, most of the time where clients are under debt counseling and all their debts have been consolidated, some debt counselors don't pay other credit providers. So it might be that that bank is not being paid by the debt counselor. So it's the responsibility for you, if your client approaches you, is that you need to obtain the statement from the debt counselor that indicates who are they paying, how much they've paid, and how the amounts that the client pays over to them are distributed. So you can see whether those credit providers are being paid. If that is the case and that bank is being paid, then you can just simply contact the bank and say, okay, this amount has been paid to you. If there are any other issues that arise and there's an issue pertaining to non-payment, then you can contact me as the paralegal, and then I'll take it up with the debt counselor. So sometimes it might be that it's not as if the banks are disrespecting the debt process, it's just that they haven't received the payment within a specified time. Also bearing in mind, banks sometimes also want, it's a negative on them that they want their money first, or they want to be paid first and stuff like that. So you can just notify the debt counselor that they need to communicate with that specific bank. And then Tandiwe has a question, consumer right to choose. What should the consumer's response when returning an item to a store and told they can not be refunded in cash, but rather back to debit credit card used at the time of purchase? I think that's normal. There's nothing untoward on that. If you made a purchase via your own card or your credit card, then it shouldn't be a problem that the money will be restored to your card again. I mean, it's a transaction and it's easier for them to refund it to where the payment was made. There's nothing untoward about it. And then Temba Gazi, who issue clearance certificate if the person was not under debt counseling review? What? Okay, if Tembe Gazi can just clarify that question, because remember, debt counseling is a specific mechanism that is used. So if you don't have, if you're not under debt counseling, and then you issued a clearance certificate, what is that clearance certificate issued for? So just try and break down your question so we can just get a bit more clarity on it. I don't understand the question as it stands. And then.
Oh, okay. Hi, Tembakazi. Do you want to explain your question?
Okay, my question is, this person pays the money to the different credit providers, then he paid off, but now he's struggling to get another. It's been 3 years now. He's struggling to get another money or loans. It flickers there in the mentions that he still owes the banks or as a credit providers. But now he needs to know who can give her that clearance certificate, because he already paid off his debt.
Okay, let's try to break down the question. So you have a client that approached you. They defaulted in payments to a bank, okay? What happened thereafter? Was there judgment taken against them, or did they approach a debt counselor in order to consolidate that debt?
No, he didn't approach anyone, any court or any debt counseling, but he arranged with the credit provider and he paid it off.
Was there an action taken against them where they in default and then there was the notice that they need to pay?
No,
That's
there is
specific.
there is no action by the credit provider to, what he did is that when he saw the summons, he didn't go to the court, he just paid the money.
Oh, so there was a summons there. Okay,
Yes,
so
yes.
what happens is that if they paid the money and there was a summons, what they need to do is they need to do what we call then a rescission of judgment if there was an order that. Pardon?
Okay.
So if there was an order that was granted against them, then they need to do what we call a rescission of judgment. Then they need to get a consent from that credit provider, which will be the bank, I assume, that they took out the loan with. Then they will say, okay, we agree that you paid this amount. Then that application will be made in court. It will be granted because they've paid off the amount. Then what they need to do, once they obtain that order, they need to then communicate, like we indicated to you, to the credit bureau and say, okay, I have this order. Can you remove this listing on my name?
Okay.
Also, mind, you're not going to be automatically given credit after you've defaulted. You're not a good payer, so no one's going to say, let me give you credit now because you've cleared this thing. The fact that you defaulted before puts you in a negative lighting. So what that client will then need to do is that they need to first obtain smaller credit before they get bigger credit. So like obtaining a clothing account so that there's a record that shows that they're able to pay off their debts, okay? Then they will get bigger amounts, so on and so forth. Okay, then Eva Shi, sorry if I'm pronouncing your name wrong. With regard to prescription, what if the credit provider has sought to make contact with within the 3-year period, but there has been no acknowledgement by the defaulting party? So for the prescription of 3 years. So here you need to remember that prescription can only be disrupted by specific scenarios. So the first scenario is that if there's a legal process that is commenced. Secondly, if the defaulting party, which is the consumer, has consented to the default by means of saying, yes, I owe, I'll pay you at a later stage. Or if that defaulting party has made smaller payments within that 3-year period, then that debt would have been disrupted. But if none of those are there, the only way that a prescription can be interrupted is within those 3 scenarios. So in the manual, once you receive it, you will see we go into greater detail as to how prescription is interrupted. Bearing in mind, like we said to you at the beginning, it's also your responsibility, once you have the guide, to go and read what the Prescription Act says about prescription so that you're in a better position to then advise your clients, okay?
Are those all the questions?
I think on our side, I think there's one that's just popped up now from Simon.
Before we get to the chat questions, Mabel has had her hand up for an hour. So if Mabel can ask her question, please. Is that okay?
Yes. That's
okay.
Thanks, Mabel.
Okay. Okay.
Yes.
Do you hear me? You hear
yes.
me?
Yes.
Yes, on my side, I'm clear to this information, but I've got one question. I've got one or two questions. can you explain the role of the National Credit Act to the client who cannot afford to pay the errors in clothing shop or in loan sharks? The second question, can the debt counselor clear your name in credit bureau after you paid and finish the debt? Thank you.
Okay, with your second question, I didn't get the first question clearly, but I got your second question. So once a debt counselor is satisfied that you paid all your debts, what they do is they make an application for a clearance certificate, where then they would get that certificate that then states that you paid off all your debts. That certificate is then made available to the credit bureau in order to remove that listing defaulted.
Yeah.
Then please just break down your first question.
Yeah. Okay. Listen, just can you explain the role of the National Credit Act to the client who cannot afford to pay the errors in clothing shop or in loan sharks? Thank you.
So a client, so you want to understand the role of the NCA to a client who's unable to pay an amount that is owed to a loan shark.
Yes.
Okay.
Who cannot afford to pay.
Yes. Remember now, if that loan shark is not registered with the NCA, then it becomes difficult for that for the NCA to play a role in that, because they're not governed by specifically by the NCA. Actually, NextSash is trying to get something going pertaining to loan sharks that are not governed by the NCA, because those are micro. So basically, it becomes difficult then for that client to get assistance from the National Consumer Tribunal or the NCT, which is the National Credit Tribunal, in order to say, okay, you are over indebted or this amounts to reckless lending, because that specific micro lender or that loan shark is not registered within the space of the National Credit Act. So again, it becomes important that when clients approach these micro lenders or lenders that they think might not be registered with the National Credit Tribunal, they need to, normally they put out a certificate that shows whether they're registered or not. Then if they are registered, then they can report them to the NCA or the NCT, sorry.
Okay. Okay, thank you.
Thank you.
Thanks, Mabel. And then we have Nokupumla, who's had her hand up. Nokupumla.
Hello. Hi.
Go for it.
Can I take a client who was a student opened an account, Student Achiever Award account in 2019 while he was still schooling. So then when he reached 25 years, he changed the account. The account was changed by the bank to the check account. He was informed by the bank that they are going to refer him to lawyers because he owes the bank 8,250, which is bank charges that accumulated from 2013 till now. So what can the client do on that case? Thank you.
Okay, Josie will answer you.
If I'm understanding you correctly, the type of account that the student had changed. So when he was 25, they changed it to a normal checking account instead of a student account. So that I think is quite standard with banks, that at the age of 25, there's sort of the assumption that you are no longer a student or that you are not studying anymore. So what he could have done or should perhaps still try to do is to prove to the bank that he is still a student. But that's only if he is a student, then they can change his status back to a student account and then he wouldn't have bank charges. So as soon as he turned 25, they basically assumed he isn't a student anymore. And therefore he is supposed to be able to pay bank charges because they assume he's now working. So if he doesn't yet work and he is still a student, then he needs to just approach the bank and take proof that he is in fact still a student or that he is currently unemployed. And perhaps that would assist.
Hello? Hi.
Yes.
Okay.
Yes.
The client is still not working. And then we as the advice office accompanied him to the bank, and the bank said there is nothing that they can do. The amount will accumulate until he is employed and pay back that bank charges, which we think now is about 10,000 now. So what must we do? Because we did refer this case to Rose Legal Aid Clinic, but they didn't respond yet.
Is he no longer a student?
No, but he is still not working. And we asked him to make an affidavit that explains that he is not working. And we give the bank the affidavit, but they say there is nothing that they can do. The amount will accumulate until he paid back that bank charges.
Okay.
That's the problem.
Thank you, Nopumla. So firstly, your client needs to go to the bank and close that account. So it stops accumulating the interest. And the bank cannot refuse him that right. He has a right to close it. So that the specific client needs to go to the bank and close the account. And then secondly, the client needs to go back to the agreement that they entered into with the contract and read what the contract states about what happens after they over 25. Then that will guide the client, particularly for this reason, for the accumulation of the amounts and the use of the account. So once they have that, once they have the terms of the contract that states, okay, this is what will happen, bearing in mind again, a client is supposed to get a monthly statement from the bank, either through an SMS, through the post, or via email. That account basically will indicate what type of account they have with the bank, what charges accrue, and then how much is on the account at the specific time, okay? And then thirdly, your client was supposed to be notified again if it is on the agreement. Once they turn 25, for example, then they needed to be notified that, okay, your account now is going to change from a student account to a normal check account because you're over the age of 25. And then fourthly, if none of these, you get no assistance with this pertaining to this, then you can either lodge a complaint. So you need to approach the bank. If you speak to someone, I don't know who you spoke to previously that gave you that information, but that's not the correct information. That's not how they should have dealt with that specific scenario. But if you get a similar response, then you need to ask to speak to the manager of that specific branch to lodge a complaint against whatever is happening against your client. Once you've lodged the complaint internally and there's a result, then if your client is not satisfied with that result, then they need to approach either the consumer tribunal or the banking tribunal, the banking ombudsman, to report this to them, and then they will do an investigation and see what the conclusion will be. Obviously, what is important here is what is the contract that the client entered into when they got that bank account opened, okay? Yes.
Thanks, Odwa. Sorry, Nokupumla, did you want to say something else? Sorry.
Yes, because we did accompany the client to the bank and speak to the bank manager, but the bank manager said there's nothing that he can do.
Yeah, it's impossible for them to say there's nothing they can do. Then you need to lodge a complaint, then they will do something about it. There's no such thing as there's nothing I can do. If there's an account that's left, that's basically not even in use. Your client is not using that account.
No.
They need to either close it. There's no point in them accumulating fees for an account that's not working, because that person is not enjoying that right that they have over that account. So there's no such thing as that there's nothing that they can do but just continue to accrue charges. You need to tell them that the client wants to close the account will be closed. You need to lodge a complaint. If they don't respond, you approach the banking ombudsman. If the banking ombudsman doesn't assist, you need to complain to the National Consumer Ombudsman, and then you'll get a result as to what will happen thereafter. If they institute an action against your client, pertaining basically what the contract will say, your client will then get their defense on what the contract stipulated. Okay. Thank you. Amanda,
Thank you. Sorry, what do I go for it?
Are there any other questions on the?
Seem to be, there are no hands raised, but there seem to be a few more on
it's
the.
Fine. We have the chat,
Yeah.
so we deal with those questions. So Simon, my question is, what really parity? We think you mean qualify us to give permission for serving the clients in our community with this service of debt credit. Is this only the invitation and the agenda of the meeting together with the manual that will prove to outlines that we have received? Amanda, I think this question will then be for you guys from Simon.
Okay, I'll address the question afterwards. You can go to, I think, in Tombi's question.
Okay. Dombi, is the debt counselor fee regulated? How much is it? Is it per consultation or per case? So like we said, you will see on the manual, we say we don't deal with debt counselors, and we don't want you to give advice pertaining to debt counselors. But debt counselors are governed by the NCA. There is a cap for the fees that they can charge for the services that they provide. So what you need to do is you need to go to the NCA and then read what it says pertaining to debt counselors. And then Duduzile, is the client using that account? If not, why not close it? Okay, I think you're referring to the bank. On our side, there are no other questions, but I see Jabulani has his hand raised, so we can deal with Jabulani.
Yeah,
Jabulani,
from the Advice Center.
Jabulani, if you can just put your question in the comment section, your connection is very bad.
Yes.
So just put your question in
it's just the noise is too slow. I think it comes later.
I think rather put your question in the comment section. It will be easier for us to respond.
How about now?
No, it's too
How
bad.
about now?
Okay, say something quickly, Jabulani.
Yes, we have a client here which is once being employed by the land reform. But now when they are applying for the grant, it appears that as they are still getting paid from the department. So they want to erase whether it's that PESA number. So we don't know which step we can take from now. Thank you.
Sorry.
Amanda,
Yeah,
that's okay.
sorry, Jabulani. Are you speaking about a social grant?
Did you get the question, Amanda?
You have someone who used to work for land reform, but they're trying to get their grant and they say no, they're still putting
Not
income.
the social grant per se.
Okay, I think that we Jabulani, we're missing each other. If you can contact.
Officially contracted to us 6 months, then it stopped.
Okay,
They are no longer working.
Okay, I don't know if maybe Khatatso got that question, and then maybe you can get some help from our helpline. But I don't think we're able to answer you now, and we really can't hear very well. So we will try, either you can put the details in the chat and we'll try to get back to you. But yeah, we really are struggling to hear you. On the question, look, this is not an accredited course, so we cannot provide you with a certificate to say that you're attended this. People, I think people assume that those who work in advice offices and who give advice on certain things, Simon, are trained in that. And yeah, so there isn't an accreditation. This training, this manual will be part of the Dula Oma school, where we'll go into much more detail for those who are going to be a part of that school. But there are no certificates to say that you've done this course. I don't know if that answers the question. Are there any more questions? Like I said, after this, you will get an email from us with a recording of this training, with a link to the videos, and we'll also try to send you the WhatsApp, a link to the WhatsApp version, so you can send it to people over WhatsApp. And then we will also send you a copy of the manual. Just to note, the copy of the manual sent to you earlier had the incorrect cover on, so please don't share that one. We will send you the proper final version of the manual. But before I end off, I just want to double check if there's any more questions. Tandi, you've unmuted.
Yeah, sorry, I got disconnected at some point. I was asking my colleagues if there was a response to the question I raised on the chat with regards to this national consumer database, which time it was on the consumer rights, the right to privacy, where you get a call, a marketing call, and you like, where did you get my details? And then you are told that it's from the national consumer database. Is there such? And how do you advise a person who asks you that kind of a question? Because it also has to do with, I think it's section 7 or section 8. I'm sure I might be mixing the sections, where you have the right to actually request that they remove your name from whatever database. But unfortunately, there's no way that you can trace
because from where I'm sitting, I'm not aware of any national database. Maybe there is. This forum may probably try and clarify that for me.
Yeah, Odwa did respond, and he did say that he wasn't aware of anything. But Odwa, do you want to add?
To add to the response, or
just to respond to to Tandiwe's question, please.
Thank you, Amanda. So Tandiwe, so we indicated that specifically to your question, you would have seen that we related to what we call POPI and also what we call the NCA, which regulates the information of consumers. So firstly, POPI, which is what is predominantly known as POPI, which is the Protection of Personal Information Act, basically states that your information is not supposed to be shared with any third party for things like this. So because in the past, POPI was not in operation, it recently came into operation. If this has been done already, then if they persist after you tell them that you don't want to receive this information anymore, like we explained to you as per the NCA, then you can report them to POPI, indicating that they're persisting, you don't know where they got your information. Secondly, you can also report them to the National Consumer Tribunal that they infringing on your right to privacy and they don't want to stop the marketing, which is the direct marketing. So you can do those two things. Alternatively, you can just tell them to stop contacting you. You will see now recently, if you do get an SMS, they have at the end, if you want to stop, respond with N or whatever, then they'll stop sending you those messages thereafter. I'm not sure about the, like I indicated previously, about the National Consumer, what did you call this? Sorry. Then
Database, I think.
Yeah, I'm not sure about the database. I've never heard of it before. So you'll see on the manual, there's a section which deals with how you can report to the NCT. So that will guide you specifically how you can send your query.
Thank you, Odwa. Jabulani, thank you for putting that on the chat. And thank you for putting your number there. I think we'll speak about who can possibly answer that question for you, and then we'll get back to you. Odwa and Josie, do you have anything more you'd like to add?
Nothing on our side, Amanda. Just a thank you from Josie and myself for affording us this opportunity to present the manual. And thank you to the participants that participated in this specific training. The questions were quite engaging, and we think that if you have any other questions relating to the manual, then you can send them through to Amanda and then she'll forward it to us. Obviously, then we'll deal with those questions as they come. But from our side, Amanda, there's nothing else we'd like to add.
Yes, thank you very, very much, Josie and Odwa, for making your time available. Our time has run out. But yes, please, you can email us any questions, and then we can try to forward them on to Stellenbosch University Law Clinic for assistance. Thank you very much to everyone who attended. I want to encourage everyone, please, to sign our petition, which is on our Black Sash website, and Esley has just posted it on the chat also. Sign up petition for basic income support. We campaign for basic income support for everyone, and these are important issues. Again, like I said, we will share the manual with everyone. Thank you so much for attending. Thank you so much for being a part of this, guys, and thank you very much to Stellenbosch University Law Clinic for all the work that they've done on this. Thank you, everyone. Have a good rest of your afternoon. Happy voting next week. And the link is in the chat. I won't close the chat yet.
Thank you, everyone. Thank you very much.
Thank you, Amanda and the Stellenbosch team.
Amanda.
Thank
Amanda, we transform. Thank you.